to the Appellate Division, First Department. We have over 5.5 hours of argument time requested, so only ask for the time that you need. We are familiar with the briefs and the records. We have looked at all your papers and are familiar with your cases. People versus Shipman is submitted. Voss versus City of New York. Appellant. Respondent? I'm going to give you 5 and 1 and 5. 495 Estates versus New York State Division of Housing. Appellant? Respondent? I'll give you 5, 1, and 5. People versus Allen L. is submitted. Kong versus Commissioner of Labor is submitted. Goldberger versus Majid. Appellant? Respondent?
Respondent, 4 minutes and 1 for Sir rebuttal.
There's no Sir rebuttal. Oh, there is. I'm sorry. You have cross appealed. So you asked for 4 and 1?
4 and 1.
Okay, 5 and 1 and 4 and 1. People versus Sharma. Appellant? Respondent? 5, 1, and 5. Han versus Chen was previously argued. Ralph Lauren Retail versus 888 Madison. Appellant?
8 and 2, please.
Respondent? I'll give you 6, 2, and 6. Mendonca versus Plaza Construction is submitted as per prior order of this court. People versus Weathers. Appellant? Respondent? I'll give you 6, 2, and 6. People versus Diallo. Appellant?
Appellant request 5 and 2.
Respondent? I'll give you 5, 1, and 5. Savolo versus New York Sports. Appellant?
Opposed, 5 and 2, please.
Respondent? 5, 2, and 5. Madison Square Garden versus Factory Mutual. Appellant? Respondent?
5.
I'll give you 6, 1, and 5. Concepcion versus LaSalle Transportation and Concepcion versus Midtown Trackage. Both of those appeals are going to be argued together. Appellant? Well, why don't we do appellant on the first case? LaSalle Transportation first. Are they not here?
I'm sorry, the appellant is apparently on their way.
The appellant's on the other side's on their way.
To the respondent.
And you're the respondent also? Okay, right. So why don't we, I'll leave it on, assuming that they will arrive here in time, and I'll give 5, 1, and 5, 1 for each side. But they're going to be argued together. Okay? Okay. First case is Voss versus City of New York. Go ahead.
May it please the court, my name is Mark Miner, the firm Zalman, Sherman & Miner, with the plaintiff appellant Voss. This is a case in which the defendants owed a duty to the infant plaintiff.
Counsel, where did the infant fall?
He fell from Umpire Rock.
From a rock?
Isn't the law clear that the defendants under those circumstances do not owe a duty with respect to natural geographic formation?
In this case, the plaintiff came from the playground, which is obviously man-made and created. They created a condition which led the infant plaintiff directly onto the rock. In regards to their duty in regards to the playground, they have a responsibility to build a playground taking into effect the hazards surrounding it, including cliffs. They have to have barriers to keep people in the playground.
Wouldn't the case have been stronger if, in fact, if the infant had fallen in the playground as opposed to on rocks that he was climbing outside the playground?
The case would be stronger if it was in the playground, but I submit to the court that the playground was on a composite play structure within the playground. The composite play structure led him directly onto the rock, which in effect became part of the playground.
Counsel, if the playground wasn't there, though, couldn't the child just as easily just gone onto the rock? And don't children, in fact, go onto the rocks all the time in Central Park, whether or not there's a playground
The
attached?
child would not have been deposited, 10 or 15 feet up on top of the rock, unless he went to the playground. Also, his mother, who was with him and brought him into the playground, would have been monitoring him. She did not know there was this separate exit from the playground onto the rock.
Counsel, was there testimony that, in fact, this child had climbed on this rock previously in the presence of the parents? And then my second question is, why isn't this an open and obvious structure, the rock formation, rather?
In regards to they were at the playground some years before. They were on a different part of the rock. They were not aware of the cliff on this part of the rock. In regards to the open obvious, it is an inherently dangerous condition. So, they would not have a duty to warn if it was open and obvious and not inherently dangerous, but here it was inherently dangerous. You can't say a 20-foot cliff is not inherently dangerous. Plus, from where he left and where there was not a knowledge that there was a cliff until he got to the top, and then he fell off.
Didn't he in fact testify, though, that he had seen it before and that he knew the cliff was there?
He testified that day. He went to the top. He saw the cliff. He went down. He went
So
back
he knew there
up.
was
He
a
fell.
cliff there. It wasn't that the cliff caught him by surprise.
No, he didn't. He saw it moments before he went back up. He looked over. He slipped off. But he wouldn't have been there if they had not let him there from the playground. They created a condition that made him much more dangerous. If they had a barrier there.
But as my colleague pointed out, the condition was always there. It was a natural rock formation, and there was a playground abutting it. That's the condition, right? But the rocks were always there.
I mean, Central Park is a landscaped, park. The whole thing is landscaped. The rock's been there for 100 years, perhaps, I don't know, but they landscaped it and they placed him there. If they put a barrier there, this never would have happened. All the National Geographic phenomenon cases either have one or two aspects to it. Either there's a barrier or a fence which the plaintiff went past, and the court held that, having gone past it and then fell from Natural Geographic phenomenon, the defendants met their duty, or it was in such, it was in a remote place, in a upstate, where there was no improvements on the land, and the court specifically said, there were no improvements, this is a natural state. This case is much more close to Aberger, where, the plaintiff fell on an embankment. There's many cases where plaintiffs fall off cliffs, embankments, etc., from an improved area, a road, a path, a dirt path.
But going back to the case you cite, my recollection of the case was that the embankment was not a Natural Geographic phenomenon, correct?
Sorry, which case? I didn't hear you.
Aberger.
An Aberger?
Yeah.
It specifically says the embankment was natural. I have the case right here, and it says.
You can answer that in counsel. You could do that.
Okay, we'll let you answer that in your rebuttal time, and we'll hear from opposing counsel.
Good afternoon. May it please the court, Eva Jerome from the New York City Law Department on behalf of respondents.
What about the
Aberger,
argument that the playground abuts the rock, therefore taking it out of those line of cases, excluding geographical formations?
the playground is a side issue and does not take this out of the body of case law this court has recognized in Torres, Melendez, and Touchage, for example. The plaintiff here fell from an undisputed natural rock outcropping, and at most, the playground was a facilitating condition, as this court has recognized in Escalade.
But what about your adversary's argument that there should have been a barrier, if not this is actually an extension of the playground?
Well, there's no testimony, there's not established fact that it's an extension of the playground. There's no testimony to that effect. And simply because it was this natural rock outcropping, it falls squarely within the natural geographical phenomena cases in which a typical landowner duty of reasonable care does not apply, even in extreme cases.
Well, you would acknowledge, though, that the rock was there first, and then the city intentionally placed the playground adjacent there, too.
Yes, I believe the rock was there for
Okay.
millennia, perhaps.
So how do you answer your friend's point, and maybe I'm just wording this a little bit different than some of my colleagues, that the thrust, it seems to me, of your friend's case is that by intentionally siting the playground next to the rock, essentially the city incorporated the rock into the playground area, which takes it out of the standard natural phenomenon case, a cliff, a body of water. Here's something that was constructed intentionally immediately adjacent to the natural phenomenon.
Well, there are a couple of points. The most important one is that the plaintiff here may have accessed, on this occasion, the rock from much lower down on the rock where the playground abuts the rock. But the plaintiff spent time and on his own traversed the surface of the rock, went up to the high point, looked over, saw that it was high, went back down, played some more, then on his own went back up knowing how high it was. And that's why it falls directly into the natural geographical phenomena cases. And in Aberger, this court actually recognized that body of case law and cited Touchage and the cliff in Touchage, and distinctly said that in Aberger it was not a natural geographical phenomenon. This court in Melendez also recognized, and I want to point out that in the case, plaintiff's attempt to distinguish the cases doesn't quite work because the holdings in Touchage, Melendez, and Torres do not turn on whether or how many fences or barriers there were, if at all. The quotes from those cases are clear. From Torres, the duty to take reasonable precautions does not extend to open and obvious conditions that are natural geographical phenomena. It did not turn on fences or warning signs. Melendez, the same thing. No duty, the city had no duty to protect bark visitors from natural features of the landscape. And in Melendez, this court recognized too that the Westbrook line of cases that holds that landlords have reasonable duties generally does not apply in natural landscape cases. I also point out the case of Divins versus Hastings on Hudson in the second department, where the plaintiff there walked from a public park onto land that had the natural geographical phenomenon and was injured, as being very similar here. And this case should be affirmed because of the fact that we fall right squarely in the natural geographical phenomenon, but also the affirmation of Peterson does not change anything, and it does not create an issue of fact. First, it's a side issue, as I explained, whether or not how the playground is designed. There was no accident in the playground. This is not a playground liability case. Peterson also never states that she is an expert in designing playgrounds. In any event, even if she were an expert, she relies on inapt guidelines, guidelines that did not exist at the time. And again, at most, the playground was facilitating condition under Escalade.
Thank you very much.
Thank you very much.
Just to follow up on the Aberger site at 193 AD 3rd 200, the court specifically said, and while the rocky terrain may have been open and obvious or even a natural part of the topography, the landowner's duty to maintain the premises in reasonably safe condition, as noted earlier, is not eliminated by the presence of an open and obvious hazard. So here they say even if it was a natural part of the topography, and this is a case that Judge Schulman took part in as a majority.
Well, didn't they distinguish there, the majority, that on the one hand, something that's simply something that's naturally a feature of the topography of land on the one hand, and a quote-unquote natural phenomenon on the other, which would trigger this body of law that your friend is relying on?
I think what we see in the Aberger case, in many cases, in that case, plaintiff was on a path that was created by the defendants where he was walking on, and he fell onto the natural phenomenon or topography, whatever you call it, the cliff. And that's the same thing here. Plaintiff was on something created by the defendants, and he fell off a cliff.
In Aberger, you just said it, it was a path created by the camp.
Correct.
And the issue is whether there was a barrier to prevent someone from rolling into the path below, which was arguably natural.
Correct.
Here, the outcropping was not, the Empire Rock was not created by the park. The playground was created by the park, and Empire Rock was near the park.
I mean, it was not
Not
near the
the
park.
same.
It was abutting the park.
True, but it's not quite the same. And here there were also bollard and chains, so that people using it knew where there was a demarcation, even though that wasn't a protected
Yeah, but the
area.
bollards and chains here had openings in it for the specific purpose of people to pass through. The defendants knew they were passing through. They foresaw them passing through. They saw them pass through afterwards. They knew, they intended it. They said it was meant to indicate a transition, but it was not a fence or barrier specifically. I mean,
Thank you very much.
as a testimony. Thank you.
The next case is 495 Estates versus DHCR.
Good afternoon. May it please the court. Jason Porpoise for New York State Division of Housing and Community Renewal, Office of Legal Affairs. Before I proceed, Your Honors, may I present you with pictures from the record as well as to request judicial notice of another pending appeal. I have pictures for you to review.
Has opposing counsel seen what you're submitting?
They're in the record, Your Honor.
Okay.
Show and tell.
Just to advise the court, the second set of pictures are from a related case that's currently pending before this court. It was before Judge Tishman in the Supreme Court, who found in favor of DHR, and now in that case, DHR is the respondent in the appeal, therefore. I'd like to start off saying that Justice Rackauer, in the instant matter, found that DHR acted arbitrary and capricious and in contravention of its own precedents, of the agency's own precedents. Those are incorrect. I submit that was an incorrect decision on the justice's part.
Counsel,
Yes.
I think one of the issues that might be a problem here is that the Department of Buildings approved the plan for the work. How should we view that? Thank you.
The simplest way I can say it is that the Department of Buildings has its own jurisdiction, which is the safety of construction and the safety of tenants, of buildings, and their set of domain is not the rent stabilization law. The purpose of the rent stabilization law, the RSL, is to protect tenants from overcharges and disruptive practices by landlords to maintain people in their houses, in their homes specifically. These are disruptive practices. The tenant has been in this premises since 1990. There has never...
Going to the Merits Council.
I'm sorry?
There's no dispute, it seems, just looking at the pictures, that there's at least some decrease in the tenant's living space. Was the decrease de minimis?
No.
Why?
Because on two reasons why. Going back, even if your honors have reviewed the law, and I did it superficially, so I don't want to be pretentious here, but with rent control, a decrease in any decrease of rental space is not permitted unless consented to by the tenant or approved by DHCR. So there are two different types of proceedings under the rent stabilization law and code. One is a mandatory reduction of rent when a landlord decreases space or reduces required services without tenant consent or without DHCR approval. The other is modification of or substitutes provision of services upon DHCR services. Now, what's going on here is that there's been a change, a decrease in services, a decrease in dwelling space, rather, which requires a mandatory decrease in rent because there was no approval.
Sir.
Yes.
I'm sorry to cut you off.
Give me.
I think what my colleague was trying to ask you is, in the decrease in dwelling space, it can be quantitative or qualitative. But there's something about the exposed gas pipes in this living room, which in it itself ironic, that suggests qualitatively that it would be a decrease in the tenant's use of that space. And the DHCR, how did they address that particular issue?
They addressed it as the Lightview case, which is cited in the brief, is that there's been a change in the use and configuration of the property, use and enjoyment, rather, of the property. A kitchen is a specialized location in a house or in a residential area. A kitchen is for cooking utensils, cooking equipment, cooking utensils, and cooking. The living room is for other purposes. You could say a bedroom if you want, but it's not a kitchen. It's a specific purpose. And the landlord has gone in there and changed the use and enjoyment of the premises that the tenant has had the right to, where there's never been exposed pipes in a living room before. This is not part of the contract. It's not part of the rent stabilization lease, and it's not part of the same terms and conditions requirement of the rent stabilization law.
Could the exposed gas pipes in the living room cause a hazard?
Yes, they could. And again, there was a violation issued by DOB for another apartment, and it was not in this case, but it was cited in the administrative determination.
Let me ask you something, Counsel. Your primary argument in this appeal is that there's been a reduction of space rather than that the work was done in an unworkmanlike manner. Is that correct, or are you making...
No, it's been both. It's been an unworkmanlike manner because of an exposed pipe in a living room. That's something that I would submit that landlords would not want in their own premises, especially after agreeing to the way it was prior, since 1990.
Okay, so let's hear from opposing counsel, and you'll have rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name's Jonathan Minikis. I am the attorney for the respondent on this appeal, 495 Estates. If it's at all appropriate...
Counsel, why hasn't there been, I'll let you address the photos in a minute, but why hasn't there been a reduction in space that's not de minimis? And why shouldn't we defer to the expertise of the DHR in making the determination that it's not de minimis?
Well, there really has been no meaningful reduction of space. If you look at the photographs in the record, and I know counsel perhaps be dramatic, has added these other two photographs. I would object to that. They're in the record. And the second photograph is not of this apartment. This is relating to a different appeal that your court will hear, but it has absolutely no relevance to this proceeding.
Counsel,
But
since we're talking about the pictures, though, and your statement that it's not necessarily a reduction in services. I'm just wondering, and who would want such a gas pipe that didn't exist for about 20 years in their apartment, and now they have this gas pipe, and if you can see in this picture, it is protruding. There's a table in front of it that can't be placed flush against the wall because now there's this pipe there. So I'm just wondering how one could look at this picture and say that that is not a reduction in living space and not some affecting some sort of quality of life, which mandates the rent reduction.
Your
Who would
Honor,
want this?
to the extent it's any reduction, and I would respectfully state, it really isn't. First of all, the table is there. All of those wires and whatever underneath it, that's all the tenants, okay? You're just looking at
I'm not
the-
talking about the wires. I'm talking about the
at the
pipes that are
piping.
protruding from the
So-
wall.
It's, if anything, it's a de minimis reduction, and that's covered by 2523.4 of the Rent Stabilization
But,
Code.
I'm sorry, I'm having problems with that argument. How can a condition, a gas pipe, an exposed gas pipe, which could be dangerous, right? I mean, if you knock into it, something happens, gas leaks, how could that be a de minimis loss of space?
So, Your Honor, there's no evidence, there's nothing in the record that would remotely suggest that this is dangerous, and the DOB, that is completely within the DOB's purview, they would not have approved these plans. So
Don't you
that's-
acknowledge, counsel, isn't the issue of whether the DOB approved the plans for this a completely different question of whether there's been a reduction in services based on a reduction in space? Aren't they two separate, completely different analysis?
Well, I was responding to the question as to whether or not it's dangerous, and I'm saying it's not. To the
But
extent
that's
that
not
the-
really necessary to make a showing that there's been
Well,
a reduction.
I was just
is there?
responding to the question, but to the extent that
No,
the...
but I'm asking you that. Does the fact, does
I don't
whether or
think
not
there
it's
are
dangerous have any impact on whether or not it's a reduction in services?
I don't think they are completely unrelated. And in fact, the DHCRs, as we point out, own precedent states that unless there is a showing that the pipe is dangerous in some manner, then there should be no reduction of services. And that's to the point. There has been no showing.
Were these
But
pipes
the-
previously behind the wall and now they're protruding outside of the wall?
But again,
Is that a yes?
the pipes are now exposed, but
Outside, protruding outside of the wall?
presently, as the photograph shows, but in West 49th Street Realty and in 40 Central Park South, Inc., it was found that an exposed pipe does not warrant a reduction of services. And the law is clear, the law by this court is that the DHCR is
Counsel, in that
required to
case-
follow its own
Counsel, I'm sorry
precedent.
to interrupt, but in that case, was it the same circumstances? There was a pipe that was outside the wall or inside the wall?
Okay, so in matter of West 49th Street Realty, the landlord had initially claimed it was inside the wall. The tenant who lived in the apartment said no, it was outside the wall. And the DHCR apparently relied upon what the tenant was stating. And in 40 Central Park South, it's silent. But the point is, in both of those decisions, they don't address whether or not it was inside, initially inside or outside the wall. It's very clear that the rulings by the DHCR in this case is that it is okay to install an exposed pipe in an apartment.
Excuse me, sir, the cases that the matters you're referencing, did those both involve pipes carrying natural gas as well? Or were they?
West 49th Street was a gas pipe, yes. And I believe is directly on point. And in those cases, in West 49th in particular, they say, the DHCR states that, it doesn't look good, as Your Honor said. Maybe you wouldn't want it in your apartment. Nobody's necessarily arguing that. But the question is whether or not you're going to tell a landlord you can never get a rent increase again, and you have to roll back the rent. When the landlord, and I believe it is pertinent, did get DOB approval, spent close to $500,000 on the project, and the alternative, and had to do an asbestos abatement, the alternative would have been to dismantle the tenant's apartments, and we're talking about I'm sorry, 125 units in this building.
Thank you, counsel. Thank you.
125 units in this
you.
building was implausible. Okay, thank you very much.
Just to quickly rebut respondent's argument that DHCR's precedents permit exposed pipes where none existed there. Just to be clear, West 49th Street Realty dealt with the replacement of one pipe with another gas pipe. That's a direct quote from the determination itself. 40 Central Park South, as Mr. Menikis rightly said, did not explain the factual content. So that case cannot be used as a precedent nor an analogy. Specifically, we don't know if there was an already existing pipe in the premises at 40 Central Park. We don't know if the pipe that was put in was replacing a previously existing exposed pipe, or if the pipe was a newly exposed pipe. With respect to taking care of the tenants, I believe, and I respectfully submit that that's a disingenuous argument, because this matter arises not only from a single rent reduction, a reduction of services complaint, but numerous complaints from the tenant that were not addressed throughout the proceedings, up to including the Article 78 proceeding. The value of money, since everything was thought out so much, they could have come to DHCR for a modification or a substitution of services request, instead of proceeding along to do what they wanted and then say, oh, DHCR, you have to follow what we say.
Thank you, counsel.
Thank you.
Goldberger versus Majid.
Good afternoon, Your Honor. Jeremy Rosenberg of counsel to Heller, Horowitz, and Feit, counsel for appellant plaintiff, as well as respondent on the cross appeal. This is a simple case, or a straightforward case of a...
Sir, what troubled me here is the nexus between Ms. Goldberger and the cash checking entity.
Yes.
Where is the paper trail that links the $150,000, I'm rounding it off, the $150,000 worth of bad checks that the defendant gave them and cashed and that bounced, linking that to Ms. Goldberger's, so that it would be the backdrop to the promissory note for the $300,000?
Well, I believe that there was testimony at the trial that, in fact, that claim was assigned.
Yeah, but that's my point. Where's the paper
I'm
trail?
sorry, there was testimony at the trial that the claim that Money Spot would have had for those monies was assigned to Judy Goldberger. So she has that right to collect, and that was pursuant to commissions that were due to her husband.
I think counsel is asking, where's the proof of that? There's an allegation it was assigned, but what proof in the record is there that there was an actual assignment of that debt from Money Spot to the plaintiff?
I don't believe there's any written documentation in the record, but
But is there any testimony from Money Spot? Did someone from Money Spot come and testify and say, hey, we assigned this debt? It was an all assignment.
No, she testified that it was assigned to her. But what's critical is...
So other than her conclusory statement, there's no...
There will be no written documentation. But what's critical is Mr. Magid, when he signed the note, he acknowledged that debt in the note. The note clearly references those bad checks. Those checks were also appended to the note. There was the
Right, but if it wasn't her obligation, it was an obligation to Money Spot, then it would not necessarily support the consideration for a promissory note.
But there was additional consideration. She gave another $150,000 of her own.
Right, but so that's $150,000 of consideration, but the promissory note was for $300,000. So to support a $300,000 promissory note, there'd have to be $300,000 of consideration. If that $150,000 was not really supported by any consideration, then it's not a
No, but that, I believe
promissory
we've
note.
set forth case law in our briefs, which provide that new consideration with service consideration for the note in its entirety.
It's only $150,000.
No, but the note is really for $300,000. The new consideration was for what was $150,000, but he acknowledged and he testified at trial that he understood he had to pay back that money, and he also understood that that was consideration for Judy giving an additional 150. There's no dispute. That was a testimony at trial. Irrespective of whether there was a written assignment from Money Spot to Judy, we have a document signed by Ilya Magid that says, I'm obligated to pay this money, even the antecedent debt. And he clearly testified at trial.
Was she obligated to pay the money, though, to Money Spot or to plaintiff? That's the question.
Well, I don't believe, Your Honor, it's in the note. It makes no difference. This note is enforceable. He made it to Judy Goldberger. That's who signed. There's only two parties
Right,
to
but
this.
there has to be, we're going back to the first question,
Right.
there has to be consideration. And for there to be consideration, she had to have somehow gotten that debt from Money Spot.
Consideration is the note itself. What her arrangement would be with Money Spot would be something separate and apart, and she did testify at trial that it was assigned to her. The court did not invalidate the debt, that portion of the old, finding that there was a standing issue. The court never reached that. Judge Feynman only said that I felt there wasn't consideration because there's no evidence that Mr. Magid got that money.
Let me put it another way. How much did your client lose? Isn't it a fact that she only lost $150,000, the consideration that she gave, as opposed to the other $150,000?
With respect to out of pocket from her own, perhaps she only gave.
So in other words, it was illusory. The other $150,000 really was an illusory amount.
No, it wasn't, because
Because you've just acknowledged there's no loss.
Mr. Magid received that $150,000. He did receive it. There's no
You
dispute.
received $150,000.
No, he received also the first, those checks were returned to Money Spot. He received the benefit in any event of that first money
That has nothing to
bounced.
do with your client.
But my client testified again. There was an assignment for what it's worth. But the fact of the matter is, we have an open, clear note, fully integrated, where, and Mr. Magid testified at trial, that he understood he was obligated to pay that money. And that's the... And
You're going to have time in rebuttal, too.
I'm sorry. Thank you.
Good afternoon, Your Honor. Daniel Rothstein for the defendants, cross-appellant Ilya Magid and respondent, defendant.
So how do you
Flora.
respond to your adversary's point that the $150,000, the fresh $150,000 serves as consideration for the entire note, and that should be the end of the discussion?
Yes, Your Honor. Thank you. Under the statute, I think it's GOB 51105, prior consideration in order to be part of a promissory note has to be explicitly defined, and the case law says that too. So here we have Mr. Magid saying, yes, I'll pay you, but it's not, I'll pay you back, because he never got it from Judy. He never got it from Mrs. Goldberg. They repeat in their papers, pay back, make good, and they hammered at that in the trial. Make good to whom? There is no evidence of an assignment except Mrs. Goldberger saying it was assigned. There are four things that are undocumented here. Supposedly, Mr. Goldberg was owed $150,000 by Money Spot. That's his testimony. There's no document. Supposedly, he assigned his right to his wife, Judy. No document. Then Money Spot supposedly assigned its claim against Ilya to Mrs. Goldberger. No document. Now,
Counsel, what's your response to opposing counsel's statement that the consideration is stated in the note, that the note states there was full consideration given for the $300,000?
Yes, Your Honor. The note does not mention Judy regarding the old checks. The note does not even mention Money Spot regarding the old checks. It just says there's $150,000 relating to the bounced checks. So the whole paper trail is missing that she got the assignment, that he got the money from her. So I go back to the statute. If that's prior consideration, it has to be explained in the note, and it's not.
Sir, I believe I understood your friend to argue that Mr. Magid's trial testimony indicated or supported the finding that there was consideration, the past consideration served as the consideration for the initial 150. Is it your position that the trial testimony is not an adequate substitute for a writing under GOL 5-1105?
Certainly, it's not, because there's no consideration. And Justice Feynman said he didn't receive the benefit of that money. If the whole story is believed, and I think the check cashing operation was clear, he got that money from Money Spot to cash checks, and then he brought it back to his so-called clients, you know, all these illegal deals. He got a commission. He didn't get he didn't take $150,000 for himself. So yes, he's an ignorant person. It's explained in the trial. He thought they were the owners of the company. They denied they were owners of the company. So yes, there's no consideration. Ignorant person in a criminal endeavor, not represented by counsel. Yes, it was an ignorant mistake. I don't want to say stupid. He's not like us, legally sophisticated.
Thank you.
I want to.
Your time's up. Thank you.
Just to address a minute, Your Honor. The note, just to be clear, the note in and of itself has the monies, as referred to in our brief, the old money, appended to the note. There's a paper trail with respect to the monies at hand. The issue of what gives to the right or not is really a red herring in this particular case, because Judge Feynman did not disallow the old monies based on a standing basis. She didn't have a proper assignment. That wasn't the reason. The reason was because she found that Ilya Magid perhaps did not receive the benefit of those checks. But he testified at trial that he knew he had to pay those checks. And in fact, he signed a document which clearly sets forth those checks as well as the new 150 as consideration. And in fact, the checks were appended. Between you and me, Your Honor, no one's signing a document reflecting old checks if you don't owe it. He knew he owed it. He testified that he owed it. And the court disallowed
He owed it. See, fair enough. He owed it. But he owed it to whom? And that's the question as to why the lack of documentation is a problem.
But it's really not, Your Honor, because again, if you look at Judge Feynman's decision, and that's the decision we appeal from, she doesn't disallow the old checks based on, I don't know if Judy Goldberger has the right to enforce that. Rather, did Ilya Magid get that money? And he clearly did. He said he did, and he signed up for that.
Thank you very much.
Thank you, Your Honor.
You have another minute.
Your Honors, I just want to the main priority here is to save the home. Justice Feynman did exactly as the CPLR requires. She compared the disputed signature with the known signature of Ilya, the signature that they rely on for the promissory note. The other issue is that this whole thing was illegal. It was money to continue an illegal check cashing operation that Mr. Goldberg pleaded guilty for. And he's basically trying to withdraw his guilty plea and his sentencing, where it's absolutely, there's no dispute here that Mr. Magid was an unlicensed broker. Mr. Goldberger denied it in his testimony, but plaintiff's counsel does not dare repeat that in their papers because Mr. Goldberger admitted that Magid was an unlicensed broker. That was in the criminal trial.
Thank you.
Thank you, Your Honors.
People versus Shiva Sharma.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Shiva Sharma. Mr. Sharma's Sixth Amendment right to confrontation was violated when an autopsy report was introduced through a doctor who had neither conducted nor been present at the autopsy and who testified to her own.
Counsel, can you start by addressing the preservation issue and the fact that it's not appear that this argument was preserved below?
Yeah, sure, Your Honor. Counsel objected to any testimony from the second medical examiner, Dr. Priel, based on her opinions drawn from the initial autopsy report. Counsel did not mention the confrontation clause, did not say I'm being denied my right to confront witnesses, but that's not necessary.
But didn't counsel also not object to the admission of the report itself, but only to that expert opinion about what was in the report?
Correct. Counsel objected to the opinions drawn from the report itself.
But did counsel, how can we construe that as counsel objecting to the admission of the report itself is my question, I guess.
Two-part answer to that, Your Honor. First of all, the most damaging testimony to my client from Dr. Priel was her opinion, based on the autopsy report, that he had been the passenger because there was bruising consistent on his hip and on his shoulder with him having been in the passenger's seat. So that's the most damaging.
But was there overwhelming evidence, in fact, that Mr. Sharma was the driver of the vehicle based on what happened at the scene? The passenger was extracted. I think they cut the roof out to take him out. Wasn't that overwhelming evidence?
There was not overwhelming evidence, Your Honor, as you're probably not surprised to hear from me. First of all, the most obvious indication that this second medical examiner's testimony was important was that at the first trial, where she did not testify, there was a mistrial based on an inability to reach a unanimous verdict. So that certainly is an indication that the second medical examiner's testimony was important. And there was also conflicting evidence about whether my client was the driver or not.
But what was the conflicting evidence? My recollection of the record was that there were a number of witnesses at the scene, because it was a horrific scene, and they testified to what was seen there. What conflicted with that? There was DNA evidence also, as I recall?
Well, there was
some DNA.
Sure. The conflicting evidence was that my client was thrown from the car. The greatest damages occurred to the driver's side of the car, yet my client had only minor injuries.
But the passenger, according to the testimony of Faso, was that he had to cut the passenger's seatbelt in order to get the deceased out of the car. Isn't that overwhelming to the fact that who was driving and who wasn't?
Well, the testimony of a single witness is not overwhelming. The defense
There were
was
other
that,
witnesses, right?
not who put him in the passenger's seat, Your Honor.
Let me just ask this question before your time runs out. In terms of the Garlic case and the Ortega case that's now pending before the Court of Appeals, would the Garlic case, we can agree, is not necessarily binding on this court, but what about all of our case law in this department that in fact says that the autopsy reports are not testimonial?
Those cases are wrong. And the Second Circuit in Garlic not only found that those cases were wrong, the Second Circuit found that there was clearly established federal Supreme Court law to the contrary. So it was not merely a finding that it was wrong, but that essentially no reasonable jurist could have found that result. So it's not a close call. I mean, ultimately, we'll see what the Court of Appeals says, but if you take the Second Circuit's opinion, Second Circuit's interpretation of Supreme Court law at its word, it is an unreasonable application of Supreme Court law, an unreasonable interpretation. So those cases, Ortega, Freycinet, John, are not only wrong, but but unreasonably wrong.
Sir, what was the testimonial aspect of this particular autopsy report?
The testimonial, the description of the injuries, for example, the description that there was bruising where the autopsy report reported there was bruising, where the second medical examiner concluded from that description of the bruising that the deceased was the passenger. So it was critical testimonial evidence. It went to the heart of the defense, and it was cited by the prosecutor in their summation to corroborate Fasso's account that he had cut the deceased out of the car.
Thank you, counsel.
Thank you.
May it please the court, Beth Fish-Cohen for the people. The defendant did not preserve his Crawford claim, not merely because he didn't use the name of the case, but because his objection was only to questions on a particular issue, which was Dr. Priel's conclusion that the decedent was the passenger. But the defense did not oppose the admission of the report other than certain redactions, did not say that the doctor who performed the autopsy needed to testify, nor did he say that Dr. Priel should not be able to testify but for the conclusions. So this is basically the opposite of a confrontation clause problem, where often the issue is that the person who testifies at trial is parroting the findings of the other person who performed the autopsy. Here, it was only the person who testified at trial who actually linked the defendant to the crime by virtue of saying where she had determined him to be seated in the car.
Counsel, I would ask you the same question in terms of the Second Circuit Garlick case and the case that's pending now before the Court of Appeals. How should we view that Garlick decision, which held that reports that deal with drug analysis and things of that nature and DNA, those are testimonial just in and of themselves. How should we view that as we move forward in this area of law?
So as my adversary and this court has noted, the Court of Appeals will address this issue in Ortega right now. New York state law still is good that the court's decisions, as recently as I know several members of the panel were on Fuller and many other cases recently, it's still good law in New York. What happens on possible habeas review, we'll see, and I guess could change in Ortega, but I think what's important here is that the harmless error argument in this case is so powerful and readily distinguishes it from Garlick. As has been noted, there was eyewitness testimony of where both the passenger and the defendant were found in the car. There was DNA evidence, there were blood stains, and the reconstruction expert, the accident reconstruction expert, explained basically how the defense theory that he was not the driver and had been thrown from the passenger seat over the console, past the driver, and landed on the other side just defied laws of physics. Although it is true that, of course, the prosecutor referred to what was said by the pathologist as to her findings, she also said, you don't need a doctor to look at the photograph of this injury. It basically, if anyone has been in a car and they see this injury on this side, it's obvious that is where the seatbelt of a passenger would cause the injury, because it was undisputed that the band across the torso was the lap belt. So although I recognize the conflict in the Second Circuit, this case is distinguishable in that there is such strong evidence. If there's no further questions, I will rest on my brief for the remaining points. Thank you.
Very much.
Two quick points. First of all, as to preservation, the law in New York was that under Fressinet and John at the time that this case was tried, was that Crawford did not apply to autopsy reports unless they directly accused the defendant. So to now require that counsel should have said, oh, I object on Crawford grounds because it applies here, notwithstanding the fact that the Court of Appeals has held to the contrary, that would have been a futile objection. It would have been pointless. It would not have served the purposes of preservation. So it's improper to require it here. And also, if there's ever a case where the interest of justice suggests we should reach an issue, it's where the Court of Appeals has held to the contrary, and counsel relies on that Court of Appeals holding in not objecting and not interposing what it would have been a futile, if not frivolous, objection. This is the case for that interest of justice review.
Thank you, Ken.
Thank you.
Next case is Ralph Lauren Retail versus 888 Madison.
May it please the court, the order appeal from should be reversed on the law and the complaint dismissed because of the overwhelming evidence in the complaint of negligence on the part of Ralph Lauren in drafting and executing the agreement at issue.
Let's assume you're correct, that there was negligence. Would the negligence go just to the unilateral mistake, or would it also go to mutual mistake?
Negligence applies to both. The doctrine of negligence will apply to mutual mistake, and there are cases on that, and it will also apply in the case of unilateral mistake. If anything...
If mutual mistake is based on a Scrivener's error, and there's clearly authority that a Scrivener's error is a basis for setting aside agreement based on mutual mistake, isn't a Scrivener's error always going to involve negligence on the part of one of the parties? That is inherently what an error is in the Scrivener aspect of a writing. So if you say that negligence precludes a Scrivener's error, a mutual mistake, aren't you saying there is no such thing as that ground for mutual mistake?
No, no, no. Look, mistake is a legal doctrine. It exists in the context of mutual mistake. It exists in the context of unilateral mistake. But for your purposes, and I think this gets to the whole issue of could there have been a mutual mistake here, a couple of points. One...
Let me interrupt you and expand on the question.
Go ahead.
There's no dispute in this case that the complaint says that the negotiations were clearly not involving an extension of the lease. It was just to keep the rate flat on the third and fourth floor. Mm-hmm. And the complaint says that up until the time the lease was actually prepared, that was the intent of both the parties, that a mistake was made, whether it was negligent or not, and as a result of that Scrivener's error mistake, a different lease was signed. Mm-hmm. Why does not accepting the allegations as true on a motion to dismiss state a base for mutual mistake based on a Scrivener's error? If they can prove that even your client, up until that time, you know, the lease was actually drafted, believe that that was the deal.
Okay. I think there are basically two, well, certainly we have the doctrine of negligence overall. We'll leave that aside. You have two arguments as to why it doesn't apply. Number one, remember an option is a unilateral right held by the tenant here. We have nothing. The landlord has no ability to control whether they exercise it or not. That's completely up to the tenant. That's number one. So it doesn't, we're not involved in that mistake. It doesn't become a bilateral contract until they exercise.
Counsel, I'm sorry, I don't understand what you're saying.
Yeah.
If the agreement, as my colleague points out, was that there was going to be no extension and there was an error, isn't that a mutual mistake?
No, Your Honor, because it starts with the assumption that a real estate contract can be formed in an oral agreement. And my argument to you is no. An oral agreement is the starting point. It is not the ending point. The ending point for the statute of frauds has to be the written agreement. They could have said anything they wanted to beforehand, but once they start negotiating the document, once they exchange drafts, once they go over words over a period of 4 weeks, once they execute it, choosing not to read it, they're bound.
So,
And
sir, if
this
I understand
agreement-
your argument correctly then,
I'm sorry?
if I understand your argument correctly, and you may very well be right, I just want to make sure I understand it, the nuance of it, that if you have a contract involving real estate that would trigger a statute of frauds requirement, or the claim is that there was evidence that the party claiming a written agreement didn't ultimately agree, didn't conform with an oral expectation. If you have either one of those situations, then Scrivener's error theory under mutual mistake would not be available, simply would not be available.
I think it might be available to you if you were talking about a true Scrivener's error. If, in fact, there was, a word that, or a number or something like that in the document, yes, I think you could probably still have a mutual mistake. But when you are starting with an oral agreement and then negotiating it over 4 weeks and then agreeing to its terms, which, by the way, has a no merger clause, has a due authority clause, has, no modification clause, and so forth, I think you are bound. This is not a Scrivener making a little error. This is someone drafting an entirely new agreement. I don't really care what happened beforehand, to answer your question bluntly. They could have said anything they wanted to. Once they start negotiating, it's a new ballgame as far as I'm concerned. Does that answer? I hope that answers your question. Going to the question you asked, Justice Singh, the interesting question raised by the respondent was whether they could be barred under unilateral mistake from making their argument due to negligence. And I just want to point out that there's a very
I'm actually
interesting...
going to let you respond to that on your rebuttal time. Yes, thank you.
All right.
Good afternoon, Your Honors. Janice McAvoy on behalf of Respondent Ralph Lauren. This is not a case about a unilateral mistake where one party thought the parties had agreed to something else, right? Here, there is an acknowledgement that the parties never agreed to renew the lease
Counsel,
early.
let me ask you about, I know we focus mostly on opposing counsel with the mutual mistake, but let me ask you about the unilateral mistake, because the cases from the First Department are generally pretty clear in requiring there not be negligence to assert a unilateral mistake. And isn't this a classic case where there was negligence on the part of your client in terms of how the lease was ultimately executed?
There was a mistake. I think by its definition, a mistake sounds in negligence. The facts, given that it was during the pandemic, during that people weren't speaking to each other, were remote, that gives rise to an issue of fact.
I think, though, the mistake was the extent, the renewal.
Correct.
But that's a mistake. The negligence was the failure to read.
The failure to read, which was also...
So that's the question. Does that failure to read take us out of unilateral mistake? Maybe you have mutual mistake as a remedy, but you don't have unilateral mistake.
It does not, Your Honors.
Why is that?
In Gesson Electric, a 2010 case from this court, the court held there was a unilateral mistake. There's a dispute over change orders in a construction agreement. The owner believed that it was settling $1.8 million in claims for $500,000. The construction company knew that it had already been paid that $1 million, so it thought that the $500,000 was settling $580,000. The owner's lawyer drafted the agreement. The owner didn't read it. Same negligence, exactly the same as in Ralph Lauren. And the court said, wait a second, there was no agreement here. You guys admit there was no meeting of the minds here. And the court held a court sitting in equity can rescind a contract for unilateral mistake if failure to rescind would unjustly enrich one party at the other's expense, and this is, I think, critical, the parties can be restored to the status quo ante without prejudice.
Counsel, you're saying that there should be no repercussions, even in terms of the unilateral mistake, for clear negligence in not reading what, because the agreement is unambiguous. There's no ambiguity in the way the agreement's written. There's no question your client had an opportunity to read the agreement. And you're saying, despite all that, your client should be able to argue that they were mistaken. If that's true, wouldn't that apply in every case, that you could go forward with a unilateral mistake argument?
No, Your Honor, it wouldn't. What's different here is the landlord acknowledges there was no agreement. In every one of the cases, you've got one party saying, I think we agreed to X. The other party is saying, I think we agreed to Y. And here, both parties admit, we didn't agree to X, but someone wrote X.
Well, so then I guess you're conceding it's not a unilateral mistake case.
It is both. It can be argued as both a unilateral and a mutual mistake. There was no agreement. There's no dispute. Landlord cannot say that this agreement reflects the meeting of the minds.
Let's follow up on what you just said. You just said it's clearly a mutual mistake. That is
No, I
your
said it
whole
can
argument.
be either.
You're saying clearly this was not what either party intended. Doesn't that mean mutual mistake?
Well,
So how can that mean unilateral?
So I guess there's a little bit of a gotcha here, right? The parties have been negotiating, keep the rent flat on the 3rd and 4th floor for 7 years. And then the landlord said, hey, Ralph Lauren, will you extend early and we'll reduce your rent? We'll reduce it. By mistake, the in-house lawyer exercised the renewal 5 years early, 7 years before it was to go into effect, at the same above market rent. The landlord got that, and I'm sure they said, yippee-ki-yay, we just got a huge windfall. They knew that Ralph Lauren had made a mistake. Their lawyer, violating his ethics, stayed silent in the face of that mistake, and they moved forward. They knew that it was in there, but they also knew that Ralph Lauren had never agreed to it. And that's what sets it apart. And negligence was involved in both Gesson Electric, which I just mentioned, where again, the principal did not read the agreement his own lawyer drafted, and in Rosenblum versus Manufacturers Trust, where again, the drafter of the contract did not read it before he signed it. Again, court said a court in equity cannot sit by and simply let one party take advantage of another party's mistake.
Counsel, I just have, before you sit down, I have one more question. With respect to mutual mistake, my question to your adversary was, how does negligence, the failure to read, come into that analysis? Can you respond?
I think if either party failed to read, then and there's a mutual mistake, courts will not enforce that agreement, because courts say we will not enforce an agreement that doesn't reflect the party's actual meeting of the minds.
So in other words, negligence has nothing to do, failure to read has nothing to do on a mutual mistake basis for rescission.
Correct, and I believe it also doesn't have anything to do with unilateral mistake, where there's unjust enrichment, which there absolutely is here, and where the parties can be restored to the status quo ante without any prejudice whatsoever.
Thank you very much.
Thank you, Your Honors.
I'm going to go back to the 2 points that I hope to make before. One, on mutual mistake. We start with the doctrine from the Court of Appeals de Silva, many cases that say mistakes to be available in equity must not have arisen from negligence where the means of knowledge were easily accessible. And if you go to our briefs, you will see that that doctrine applies equally in the context of mutual mistake and in the context...
Let me ask you about that, because the cases that you cite that talk about negligence, aren't they fraud cases versus unjust enrichment cases where there's a distinction being made between your claiming a unilateral mistake based on fraud versus unilateral mistake based on unjust enrichment?
I understand your question, and it leads to where I was going to go when the red light came on. So there is a body of cases that talk about fraud, and yes, we cite the Eldad case, and that talks about fraud. And then you have the series of cases that Janice mentioned, the Gessen case, the Hellenic case. There are other cases like that. And as far as I can see, the only jurist to directly address this was Justice Kornreich in the Vassbinder decision, and I'd encourage you to read it because she says, look, I've seen the fraud cases, I see the unjust enrichment cases. I'm not going to try to reconcile them, even though she is aware of the tension that you're talking about, because she says, courts will not find there to be the requisite fraud or unjust enrichment if the party seeking rescission was unreasonable in how it entered into the contract. She concludes, in other words, a party who fails to take ordinary care and acts negligently in entering into a contract will not be able to claim unjust enrichment. So you don't get to claim unjust enrichment free, and you're somehow freed from the claim of negligence.
Thank you. Are there any more questions from the bench? Thank you very much.
One last?
No, thank you.
All right, thank you so much, Your Honor.
The next case is People versus Weathers.
Good morning, Your Honors, and may it please the Court. I'm Stephanie Sonsino on behalf of John Weathers with the Office of the Appellate Defender. Cases like this are why Batson exists. The state provided transparently pretextual reasons for striking 5 out of 6 prospective black jurors. The uncritical acceptance of pretextual reasons for race-based jury picking violated Mr. Weathers' constitutional right to a fair trial and harms minorities more broadly by reinforcing stereotypes rooted in prejudice.
Counsel, can you, I understand that we'll get back to the Batson issue, but can you address the issue of the unnoticed statement?
Yes, of course. In this case, the prosecutor was permitted to question Detective Vidal about statements Mr. Weathers allegedly made to him regarding the stolen jewelry that were never noticed prior to trial. That was a clear violation of the notice requirement under CPL 71030. There was no remedy provided. At trial, the prosecutor mistakenly asserted that the statements had been noticed, and the court conflated the suppression remedy with the preclusion remedy that was...
These were statements within a statement, so to speak, right? There were other notice statements around that time that had been given, and then there were certain statements relating to that same line of questioning, or time of questioning rather, that weren't even, that were never noticed to the defendant.
Yes. So the statements that were noticed were all statements that regarded the subject matter of what occurred immediately before, during, and after the robbery. The statement that was unnoticed was a statement that Mr. Weathers allegedly related to Detective Vidal, saying that earlier in the day, he had asked the victim about the value of his jewelry because he wanted to borrow it to go on a trip.
Why wasn't, assuming that the statement, we agree with you, why isn't it harmless error?
Because the people's case relied on Mr. Weathers' purported interest in the jewelry in order to prove intent. This was a purely circumstantial case. The only other proof that Mr. Weathers had any awareness of the jewelry came from the complaining witness, the victim, who was a known con man, who had a long history of theft, and who the prosecutor himself, during summation, suggested was not credible when he told the jury that he had bought a car with his mother's credit card. In such a case where that hinged on the evidence proffered by an arguably incredible witness, having that same evidence, or actually distinctly somewhat different evidence, but a different version of that same evidence produced by Detective Vidal was critical.
You can address the Batson issue if you like, before your time runs out.
Oh, certainly, yeah.
Or if I may pull you in yet another direction, would you mind discussing your legal sufficiency / weight of the evidence argument with respect to the robbery 1 and assault 1 convictions?
Yes, certainly. First of all, starting with the assault conviction, there was absolutely zero evidence here that Mr. Weathers intended to harm Mr. Monmarin with a deadly weapon. Indeed, the deadly weapon charge was dismissed because there was absolutely zero evidence that Mr. Weathers had any knowledge that Mr. Johnson ever possessed a deadly weapon. And for very similar reasons, the robbery charge should be dismissed, because the only way to conclude that Mr. Weathers had any involvement in this crime is to speculate as to what he discussed over the phone or in the club with Mr. Johnson. Absent that speculation, there was simply zero evidence tying Mr. Weathers to this case. No jewelry was recovered, and there was no other evidence whatsoever. Sorry, excuse me, Your Honor. And
You want to address the Batson challenge now?
Sure, thank you. Yes, so as to the Batson challenge, first of all, the prosecutor struck 5 out of 6 black panelists peremptorily. Second of all, he was found to have discriminated against one of them when he stated that he had struck her because he did not like her demeanor, and he felt that she did not like his, quote, vibe. The court found that he had racially discriminated against one juror, Ms. Brown. Therefore, when he claimed that he had struck Ms. Bailey and Mr. Murray due to their unemployment, that should have been facially viewed skeptically to begin with, but it was all...
Isn't that a basis, that's a proper basis for a preemptory challenge, the employment status?
It can be. In this case, however, it was not, and it was not for several reasons. First of all, it was unevenly applied. The prosecutor permitted Ms. Rosado, who was not a black person, to sit on the jury despite the fact that she was unemployed. And also in this case, the prosecutor failed to explain how the prospective jurors' unemployment bore any relation to their ability to evaluate the fairly simple facts of this case. And critically, the prosecutor didn't ask a single question of any of the jurors regarding their employment status.
Thank you.
Thank you.
Good afternoon. May it please the court. Rachel Bond for the people. I will also begin with the Batson issue unless the court has questions on the other issues first.
Well, why don't you address the statement issue? Why the statement that was not noticed, is that harmless error?
Yes, here is entirely harmless error because the exact same statement had already come in at trial. The jury had already heard it in a completely permissible form from the victim about a phone call he had had with the defendant. Not only that, but there was overwhelming other...
I'm sorry, did he testify that he asked the victim about the value of his jewelry?
The victim testified that he had gotten a phone call from the defendant and the defendant asked about the value of his jewelry.
Right, but what other evidence other than the victim's testimony was there to support that evidence other than the statement that arguably should not have been admitted?
Sure, there was other overwhelming evidence here that the defendant was involved in planning and carrying out this robbery and assault. Notably, the surveillance video showed defendant and his co-defendant conferring multiple times throughout the evening. The phone records also showed that they called each other, I believe it was 35 times in the hours immediately preceding and afterward the robbery. And then after a couple of days had passed, they in fact
But was there any other evidence that he had ever talked with the victim about the value of the jewelry other than the victim's statement?
Other than the victim's statements, aside from the officer's statement, or the officer's testimony that he had asked defendant about
Wasn't
that,
that,
no.
assuming for purposes of my question that that should not have been admitted because it was not properly noticed, isn't that pretty compelling testimony that's detrimental to the defendant?
So
That he himself corroborated that he asked about the value of the jewelry, would that potentially be a clincher for a jury in terms of the evidence they're hearing?
So I think that the victim's testimony was powerful enough on its own to support a conviction here. The victim testified
No
credibly.
issues about the victim's credibility, as your adversary pointed out?
There were indeed issues. They were fully aired before the jury, and
Well, there were issues of credibility, and so it wasn't, as my colleague pointed out, when the victim corroborates that, that's the linchpin, it's over.
so I don't think that that means that it's over. I'm not, certainly the best practice would have been to notice the statement. That obviously should have occurred. But I do think that even taking out the statement, the other evidence at the trial fully supported the jury's verdict here, and that ultimately—
How could we know, though, whether or not that was or was not, assuming, which I am going to assume that it was improperly submitted, since it clearly was not noticed, there's no dispute that statement wasn't noticed. How can we know that the jury would have come out with the verdict it did without that piece of evidence?
So the standard here is to find whether or not the jury would likely have acquitted the defendant. And I don't think that that's likely here because of the other evidence, because of the fact that there were phone calls, the surveillance video corroborated the victim. The victim had no reason to lie about what happened here. There were credibility issues as to his criminal history, but those were fully aired before the jury, and they had every reason to credit his testimony, especially the surveillance video really corroborated his testimony of the events of that night.
We also go to the other issue of what evidence was this to support that he had knowledge that a gun was going to be used in the commission of this crime.
Sure. So in the surveillance video, the co-defendant Johnson was patted down when he went into the club, which would lead to an inference that he doesn't have the gun when he goes into the club. However, later, after he leaves the club, he gets into the car and then rummages around in it and then gets back out of the car. The car then drives away. So at that point, it's reasonable to infer that he's gotten the gun at that point.
Well, how would the defendant know all of it? What's the evidence that the defendant knew about him being patted down? How does this get linked to the defendant?
Yes, so after that, the defendant and Johnson confer multiple times. Defendant is seen then calling the victim to the location.
But how was that evidence that he knew he had a gun?
So I think it's reasonable to infer there, and it was reasonable for the jury to infer that he knew that Johnson had a gun at that point, and also the fact that he was helping to plan a robbery leads to the inference that he was okay with some injury occurring to the victim if he ran away or if he forcibly tried to.
Don't you have to prove that he knew that a deadly weapon would be used?
We're required to prove that he had the same requisite intent acting in concert with Johnson. So that he had to know and essentially be okay with Johnson using a gun. Not that he necessarily intended to use the gun himself, not necessarily that he told Johnson to get the gun. That was the difference between the gun charges and the assault charge.
Almost sounds like you're saying the fact that he used a gun is evidence and he knew he'd use a gun.
What I am saying is that the surveillance video leads to an inference that the defendant knew that Johnson had a gun and that he was okay with him using it. I think also the fact that he was planning a robbery leads to an inference that he was okay with some sort of injury occurring to the victim.
But some sort of injury would make it robbery 2, not robbery 1 or assault 1, right?
So
it's the serious injury or the use of the deadly weapon that would
yes, correct.
Increase significantly the gravity of the offenses.
Yes, correct. I'm sorry. My point is that the fact that he was planning this robbery and that he had conferred with Johnson numerous times, including 35 phone calls, that he was well acquainted with the details of the plan, and that would lead the jury to have every reason to infer that he knew he had a gun, he was okay with him using it, he knew that they were going to rob him of this jewelry, and that he intended for all of those things to occur.
Thank you very much.
Thank you.
Hi, sorry. First of all, the statement that, the unnoticed statement was not exactly the same statement that Mr. Manorine gave. Mr. Manorine testified that Mr. Weathers asked about the value of the stolen jewelry because he wanted to buy that same jewelry in the Diamond District. Detective Vidal testified that Mr. Weathers asked about the value of the stolen jewelry because he wanted to borrow it to go on a trip to Puerto Rico. That divergence was a critical divergence, I think, in addition to the fact that the detective validated the most critical and really only evidence that Mr. Weathers had any possible knowledge about this robbery. It also suggested that, you know, there was maybe some shifting of narrative over time, right? And that was critical as well before the jury. And contrary to what my colleague says, the surveillance video showing that the two spoke or that Mr. Johnson was patted down before entering the club does not prove by any means when or where Mr. Johnson had a gun on him. It is entirely possible that he was patted down but had the gun hidden somewhere else and didn't get caught with it. It's entirely possible that he got his gun somewhere else at some other time. And it's entirely possible that the two spoke about any number of different topics, such as the women they were with, the drinks they were drinking, whatever else, or whatever other nefarious things they might have been involved with, without talking about the gun or the alleged planned robbery. In short, the only way to conclude that Mr. Weathers was guilty in this case is to speculate as to what he spoke with Mr. Johnson about. I would also add quickly that Mr. Weathers was visibly intoxicated on the surveillance video. He followed the victim to the hospital drunkenly after having called police officers over himself to aid the victim. And also, his criminal history is one of nothing but small misdemeanors. There's nothing remotely like this in his history.
Thank you. The next case is People versus Diallo.
Good afternoon, and may it please the court. Excuse me, Paul Anderson for the people. Your Honors, if we just confine ourselves to the facts in the decision here, the court still erred in finding that the officers did not have the reasonable suspicion or the founded suspicion of criminal activity here, making it a level 2.
Why shouldn't we? And it's a question that all of us ask when the defendant loses the motion. Why shouldn't we defer to the trial court's findings on this issue?
Well, in terms of the trial court's factual findings here, 1, that there was a heavy swinging bulge in the left side of the jacket. 2, that when the defendant saw and approached the police van, he became extremely nervous. And then 3, he then clinched that swinging bulge to stop it. Those facts, that's what the lower court found. And those facts, as a matter of law, going to the legal side of the mixed question, give rise to level 2 founded suspicion. And that's been the law of this department. People v. Rodriguez in 1994. That was a case which...
Is there the bulge?
Yes.
A shape of a gun? Any testimony that one might suggest that in fact there's a weapon?
The testimony was that it was heavy swing, and the officer
Could be rocks, right? Could be rocks in the pocket?
Yes, Your Honor. And on its own, if that was the only fact the court credited, then I would have that uphill battle.
There was no testimony that this was a high crime area, that he was a known suspect, or he matched the identity of somebody they were looking for. In fact, this was a person walking down the street with a heavy pocket, which could have also contained a cell phone, for all we know.
Absolutely, Your Honor. And again, in a vacuum, on its own, that would be innocuous. And that's what the court limited itself to, but that you have to consider the totality of the circumstances. The court also credited that this defendant became very nervous. That is the court's quotation, very nervous. We kept looking at the police van and then clinched.
He kept continuing walking in the direction of the police van, though, right?
Yes, because that was his destination, and then walked there, clinched it to stop it from swinging. And that should be enough for the officers who are in an unmarked car observing this reaction to police to say, for an officer to be like, what do you have in your pocket? What are you afraid of? And that's a level 2 intrusion. If this was a frisk or a level 3 seizure, I would agree that that's too much. But in the law This is no violation of the state constitution.
Why not, I'm sorry, just why not, why wouldn't that be a level 1?
It could be a level 1, but it can also be a level 2 in that, just like in Rodriguez, when the defendant there had the bag, approached the officers, saw the officers, reacted, changed his stance, put the bag behind him to nearly stop or to try to, that would give an officer a founded suspicion that there's something criminal in that bag or contraband that he doesn't want.
But at that point, the way you describe it, that would in fact be a level 3 stop, right? And you would require some more articulable facts, not just that we saw something heavy and we assumed that it was a gun. You can't act on a hunch that way.
It's not a hunch if the officer, and once again, this is what was credited by the lower court, observed how nervous this person was in relation to the bulge in response to the police presence here. Altogether, that creates the nexus here. I agree. On its own, nervousness around police, not enough for level 2. On its own, a bulge swinging, not enough for level 2. But when an officer sees the reaction and someone having all of that nexus together, that is enough.
He didn't change his route. He kept going, and then the police followed him and cut him off, yelling, "Stop." Well, how should we view that phrasing, "stop"?
Once again, that is the law of this department and of the Court of Appeals, that police are allowed to say, "Stop, police," in order to engage in questioning. This wasn't a seizure here. That's more in this department in 2012. You're allowed to say, "Stop." This has been the law of New York, and it makes sense for an officer not to be able to see this unfolding in front of him, which, if we look at DeBoer, the whole point
Well, then anyone walking down the street, the police officer says, "Stop." That's it. They have the right to do that?
the police can say stop, and the person
We
can
had a
keep
hunch.
walking away. But once again, if the police have found a suspicion, like we have here, consistent with this court's holding in Rodriguez, the police can say stop, the police can ask a question, and once again, in Rodriguez and more here, which the court below didn't even address, just jumped straight to, I find this to be a seizure. And then later in the conclusion, also writes that this might have been a level, he had the common law right to inquire. But altogether here, what we have are the three facts, or the three credited observations, creating that nexus of this bulge, and then the nervousness around the bulge, clinching it, trying to stop it from swinging as he walks by what he believes where police would be to be able to see it, not realizing that there are police in an unmarked car observing this whole thing happening. Of course, the police can go up and be like, hey, what are you nervous about?
Thank you, counsel.
Thank you.
Good afternoon. May it please the court. Ellie Marcus, Bronx Defenders, on behalf of the respondent, Cherno Diallo. As this court has pointed out when questioning the prosecution, the conduct here was entirely innocuous. And
well, what about this, the adversary's indication there was nervousness? He, particularly in light of there was this marked police van right there, and he clenched his side. Is that enough?
no, while that may be enough for a level 1, as the hearing court found, it was not enough to support founded suspicion of criminality here, and that is, according to this court's own precedent, that's been examined and reviewed by this court in People versus Crawford, in People versus Powell, in People versus Cornelius.
When they yelled stop to him, they didn't have their guns drawn. They were in their cars, presumably. Is that, what's wrong with that?
Well, so I think if in order, there's a question here, right, as to whether there's two issues here. Number one is whether the police observations allowed them to initiate a level 2 encounter if they had founded suspicion of criminality. The trial court found that that was not the case based on these innocuous observations. The second issue is and the court can affirm on that ground based on the record and based on the findings that the hearing court has found. But the second issue is then what the characterization of the police conduct when engaging and initiating the encounter with Mr. Diallo was, whether that was a level 2 or a level 3. The court found that it was a level 3, and as it's consistent with Bora, as we've argued in our briefing, that to make that conclusion, to conclude that based on, in addition to the order to stop police, based on the record and the other conduct that the police officers had done at that point, that that gave rise to a level 3, which again, the police did not have based on the innocuous observations that they had made. But either way, at its inception, the observations of the officers here, and I think the prosecution's characterizations of the conduct here as giving rise to some founded suspicion of criminality is belied by the case law and sets forth a new sort of standard for evaluating innocuous conduct. That is not what the standard has been.
I think your adversary would argue, as my colleague pointed out, that bulge in the pocket, nervousness, and clinching going by a marked police van, would that give some level of suspicion sufficient to at least a level 2?
No, and that is, I think if you look at this court's and the Court of Appeals analysis of conduct that is readily capable of an innocent interpretation, it cannot give rise to founded suspicion of criminality. And here we have no visible outline of a firearm, none of those telltale signs that the courts have.
What's missing? What's missing from the picture?
What's missing is anything that would suggest that this is contraband. And this court has said in Crawford, the Court of Appeals in Howard has noted that while it could be contraband, that is not enough to generate founded suspicion of criminality when an observation could also be innocuous and readily susceptible of an innocent interpretation. And as your honors have noted, having something heavy in your pocket and holding it as you walk in the direction of a parked police van, not changing your pace, not changing direction, is far less than what the case law has found to not give rise to level 2 with additional factors such as...
What about your friend seems to place a lot of a reliance on our decision in People versus Rodriguez from 1994. How do you distinguish Rodriguez in light of the primacy he's giving to that case in his argument?
Certainly. Well, I would note that People versus Rodriguez, I would say, is an outlier. It is from 1994. I'd note that this court has addressed similar facts in People versus Crawford as of 2011, which we addressed in our brief on page 25, where officers were in an unmarked car watching someone walking alone at night adjust something in his pockets by cupping it on the outside of his pocket and repeatedly adjusting it. The object created a bulge and was described by the officer as looking heavy. The officer then engaged in a level 1 encounter, which the court found that was enough for level 1. It was not founded suspicion of criminality. And in the context of that encounter, observed the object closer and sought to be a 5 or 6 inch oblong shaped object. The court, when the defendant then fled during that encounter, the court found that that was at most a level 1, that the officers did not have the right to pursue. So I would note that Rodriguez is, I believe, an outlier. It's from 1994, but I'd also note that the posture is somewhat different than it is here. That was an affirmance of the lower court's decision. We don't know exactly all of the facts, but even when looking at the facts at issue in Rodriguez, they're distinguishable from those here. In that case, there was clearly evasive conduct to avoid and change direction, get into a building, and bang on a buzzer, clearly in response to police presence, which we just simply don't have here. We have someone continuing to walk in the direction of a police car.
Thank you, counsel.
Thank you.
I think it's important to note that from what the testifying officer's vantage point was seeing this unfold and seeing the actual reaction of defendant to seeing the police van and changing that conduct. Had it been an officer who was only in that police van and saw someone walking by grabbing their pocket, that I believe would be not enough. But here, and that would be more similar to Crawford, in which you'd have an observation not in response to police conduct, just grabbing. But here we have the 3 observations I meant: the nervousness, the bulge, the reaction to grab, and the court. When that's what the court credited in A3 in the decision. But then in A5, when going into how do I synthesize this, only applied the swinging bulge, and that was an error here. And if your honors have no question, I ask that you reverse. Thank you.
Thank you. The next case is Savola versus New York Sports.
Good afternoon, Your Honors. Robert Halpern for the plaintiff appellant, and may it please the court. The lower court erred by overlooking a number of factual issues that should have been resolved at trial. And I can give an example or two. The court said that the appellant received copies of the employment handbook, which had referenced the vacation forfeiture policy. But the only evidence of this is from the COO, who was her direct supervisor, and he testified at his deposition that she was given 2 copies of the handbook. She denies receiving the handbook at all, and my friend on the other side, in an affirmation, he says that there was only 1 copy of the handbook available at the time. So we have a clear credibility issue here that the court should not have resolved, but should have
Can you
taken to
address really
trial.
the sort of the primary issue, in my mind at least, is with respect to, the chunk of the claim is with respect to the referral business. Was the court in error in granting summary judgment to the defendant on that claim?
I'm sorry, I missed part of that.
The referral business.
The referral business, that was one of the 4 claims, and it's the claim that my friend has put a great deal of emphasis on. The court was in error because the court based its decision on an Excel spreadsheet, which was first introduced in reply through an affidavit of Dr. McCulloch, who owns the practice. And the claimant, the appellant, denies ever having seen this. It was never presented during years of litigation. The first time we saw it was in the reply brief. We objected to it. But also, Dr. McCulloch was careful not to say that it was even provided to the appellant. He just says we had these Excel spreadsheets. If you look at the spreadsheet itself, which is on...
Well, let's assume for argument's sake that the defendant's made a prima facie showing with respect to the referral business. How did you raise an issue of fact saying that, you know, in the multiple 500, 600 visits to various offices, business was generated?
Well, that is actually the problem. Because there was no tracking system, there was no way of her knowing when she was generating business. She could not be calling 500 contact offices, so she was relying on some sort of tracking system to tell her when business was generated. This is really...
What about the fact that you offered a flash drive during discovery, which would have allegedly contained this information, and you declined to review it and go through the flash drive to determine whether there was evidence to support your claim?
Right. The flash drive, which I never actually saw, supposedly had
But you could have seen if you wished to.
The problem was that the flash drive was raw data, and it would have required me to actually process the raw data, do tallies of it, and I would have become a witness in the case, and I may not have even been able to represent my client anymore. But also, my friend on the other side...
I've never heard that argument before. Because you're going through the discovery and assessing the discovery, you'd become a witness?
Well, if I had to analyze the data, because it was raw data, it was just lists of, it was patient intake forms
Why couldn't your client analyze the data, since it's your client who's making the claim about the referrals?
We possibly could have had somebody else analyze the data, but we didn't think we needed that data to prove our case, because our case was that she was unable to track during her work. And also, my friend even said that he had conducted his own studies, which he declared were, I mentioned this in a footnote, he said these studies were useless. So at that point, we didn't think it was worth our time to go through it ourselves if he was declaring that these studies were useless. And
You want to address the unused vacation?
I'm sorry, the
Unused vacation, what's the contractual basis? Don't you need a contractual basis for the claim that you're entitled to reimbursement for unused vacation?
No, actually, under the labor law, Your Honor, they're required to post the vacation policy. They could have informed her of it through the handbook, but as I said, there was a issue of fact as to whether or not she received it.
Her offer letter didn't contain any information about that, so presumably it's not part of the contract then, right?
The offering letter just mentioned the number of days. It did not have a policy.
So
And it didn't say that these days would carry over. It doesn't, there's no language.
right, but it's the Department of Labor policy that if there's no written policy, then you accrue the vacation time and you should be able to cash it in.
Thank you. Your
Thank you.
time rebuttal.
May it please the court. My name is Ken McCulloch, and I represent New York Sports Insurance and all the other respondents. I think the court, first of all, any questions you have, I'd like to have them right away. But I think the court hit on one of the key issues here. When you talk about...
Let's talk about the claims based on failure to provide health insurance or 401k plan. Aren't there disputed issues of fact in this case about whether or not those plans were or were not provided? One side says they were and one side says they weren't.
Excuse me, what was provided or not provided?
Whether a health plan and a 401k plan were provided to plaintiff. The contract says she was supposed to be provided with them. She's claiming that she was not provided with them.
Yes.
So isn't there a disputed issue of fact about whether or not they were in fact provided?
The issue she raised is an issue under ERISA.
But counsel, didn't the federal court already hold that these claims were not preempted under ERISA in its determination?
That issue was not decided in this case.
Wasn't it decided in the federal court, though, case?
This court, no, yes.
That's how it got remanded back to the state court, because they determined that it was not preempted and that there was not an ERISA issue because none of this had ever been provided yet. It's just a claim that it should have been provided.
If I submit, the district court, federal district court was wrong, but we would not...
We shouldn't follow the federal district court?
We were not allowed to take an appeal. You can't take an appeal from an order of remand. So we couldn't take an appeal. So we're back in the state court. And the issue is basically de novo when it's in the state court. Now, this court below didn't get into whether there was preemption or not, but it did say there were no facts to justify the claim.
And that was my question to you to begin, since there seems to be a dispute. One side says it was offered, and one side said it wasn't. Why isn't that a disputed issue?
There was another basic issue. There was no claim for any damages. She never said, I lost money. Excuse me. She never said, I lost the opportunity to go into a health plan, or I lost the opportunity to participate in a 401k plan.
Counsel, isn't it premature to make that kind of determination at this point?
Excuse me?
Isn't it premature to make that kind of determination at this point in terms of whether or not the claim should survive?
No, at this point, the decision has to be made, and whether or not the claims that she was making are preempted by ERISA. And we argue that they were preempted by ERISA. And that those are claims that can only be made under ERISA. And that's because there are claims basically against the fund. And what she's claiming is that the employer, by accident or by intention, denied her the opportunity to participate in a plan, whether it was that's her basic claim. And that is an ERISA claim, and there's plenty of cases cited in the brief that say that's an ERISA claim and should be asserted as an ERISA claim.
Okay, let's talk for a moment about the transportation reimbursement.
Excuse me? What?
Why shouldn't she be able to pursue her claim for the transportation reimbursement?
Because we ask for reimbursement, we ask for justification for the reimbursement. And what led to that was an incident in March when she got suspended on March 2nd for failing to go to a meeting. And she was told not to return to work until she was told. And then March 30th, at the end of the month, she didn't get paid for 2 weeks because that was the suspension period that the company determined to give her. And she said, I worked all during that time period. And she had been specifically told not to work during that time period. But the company she was working completely independent. They were not monitoring at all. She wasn't coming to an office. She wasn't reporting, doing anything that would lead. So on that, when they said, okay, we'll pay you for that 2 weeks, but From now on, going forward, I'm going to examine your records very closely, and I want substantiation for your travel expenses. That was in the memo of April 6 from Scott Freifeld to the plaintiff. And so that was a turning point. And at that point, there were 5 invoices yet to be paid. Incidentally, all of the invoices she submitted 4. 3 were adjusted. The company didn't say anything, but they did adjust it. So nothing was vested here, and she had no vested right to.
Thank you, counsel.
Counsel, can you address the ERISA issue, please?
I'm sorry, I missed that.
Address the ERISA issue.
The ERISA, yes. As the court is aware, that was litigated in federal court. And my friend is correct that it was, well, the procedure, the lower court did not rule on that at all, so I'm not sure where it is procedurally before this court. There's no ruling from the lower court on that. Our position on that is that the claim for health care benefits does not relate to the actual ERISA health care plan. It does not require reference to the plan or the terms of the plan. That's what the federal court decided. That's our position on the ERISA preemption argument. And just turning to a moment to the mileage issue, the claimant had submitted 9 mileage invoices. At no point during her employment did anybody complain that she was not properly documenting. All the complaints came after she resigned. There was one email on her very last day of work that said going forward she will have to produce certain documentation. But it's really an after-the-fact effort to impose rules on her. Thank you, Your Honors.
Thank you very much. Madison Square Garden versus Factory Mutual.
Good afternoon, Your Honors. May it please the court, Kirk Passage for Madison Square Garden and the other appellants. I think at the conclusion of the briefing, the landscape before this court changed with the Court of Appeals decision to consider the consolidated case, with the issuance in California of the case involving the Sacramento Kings, and with the Vermont Supreme Court's decision in Huntington Ingalls. I say that because the insurers argued that consolidated would dispose of this case. We think this case is very different. We have allegations of
How is it different?
Pardon me?
You make that argument. I'm just curious. How is this case different from the restaurant cases?
First of all, we couldn't be open. The restaurants were open. Second, we alleged and cited science.
First of all, what?
The restaurants could be open, and did stay open for some operations. Madison Square Garden, Radio City, the other venues were closed. We alleged
why should that make a difference in terms of the actual issue with respect to direct physical loss or damage?
Well, if you're talking about direct physical loss or damage, and remember, direct is not part of the phrase in 2 of the 4 policies, which also distinguishes consolidated.
Counsel, let's backtrack a minute, because what consolidated said is that the restaurants claims failure to allege that their venue suffered physical damage from the COVID-19 virus. Isn't that the identical issue that is in this case, whether or not Madison Square Garden suffered physical damage from the COVID-19 virus? And since our court has conclusively determined that issue, how can consolidated not be controlling, since that's the exact issue in both cases?
The issue is the same, but the facts are not the same.
Right, but the legal issue upon which it was decided, which is that COVID-19 is not physical damage, and both policies require, at a minimum, they both require physical damage to succeed in these claims. How can we not be controlled by that decision?
I would submit you can't be controlled by the decision because the court was considering the allegations before it, as was this department. Our allegations of the facts involved are different. We allege alteration. We allege that the virus attaches to surfaces.
Well, let's talk about that part, because I understand you're trying to distinguish the industry per se between the restaurants, they were open, but COVID-19 was COVID-19, and it affected, it didn't affect it affected everyone equally.
Well, that's not true, Your Honor, in this respect. We know because the Jazz-Knicks game was interrupted before it started, after workouts before the game, because Rudy Gobert had COVID and it was confirmed he had COVID. We know that the Westchester Knicks, which is the G League affiliate, were in the containment zone that was set up with the National Guard around Westchester. None of that is present in the consolidated case, and we have a civil authority claim based on that.
But that is a very thorough decision, and the heart of that decision is, again, physical damage. COVID-19 is not physical damage. So if COVID-19 is not physical damage in that case, how can it be physical damage in this case? And the reasoning, which was very extensive in that particular case, was because it doesn't adhere to surfaces. It's something that disappears. It's not like mold or other type of contaminants that that adhere to the physical structure of the premises.
No,
so
I don't think
it wasn't based on it being a restaurant business versus some other type of business. It was based on the nature of COVID-19 and it being a virus.
Well, part of it was restaurant because they could stay open, but what Consolidated didn't decide was the science here. Consolidated said that the allegations were conclusory and you need more. We allege more. We allege that the virus attaches to surfaces and maintains on surfaces for 28 days, and we cited scientific studies to support that. That wasn't in Consolidated. We allege that it lingers in the airspace and spreads in the airspace. If we were open, then every time a person with COVID, and remember the science is a lot of those cases are asymptomatic or non-symptomatic. There was no testing available in the early days. Every time a person with the virus would walk into a facility, the virus would be re-entrained in the air. It could land on the surfaces
But
where
that would happen at a restaurant as well, right? And so, again, how is it distinguished? You're just merely talking about the loss of use, not any physical damage.
Well, they are different things, and our physical damage point is Consolidated had to be determined on the allegations before it. Our allegations are different. Consolidated alleged conclusions only. We don't.
How, sir, should we define from your policies, not Consolidated's, but in your policies, the phrase physical loss or damage? What definition should we give that?
I would agree that it requires some physical alteration, but it doesn't require that the alteration be visible to the naked eye. That's something else different about our allegations. We allege what this insurance company knew, these insurance companies knew for decades about pandemics. We allege they knew the case law going back 50 years that said microscopic was enough as long as there was some alteration of property. We don't have direct here.
But did it alter, you mentioned a 28-day benchmark that the virus could survive on a surface. Is that an alteration, such a fleeting amount of, relatively fleeting amount of time compared to normally these are permanent alterations?
Well, the other cases that were cited, and that's why we point to the Vermont decision of the Sacramento Kings. I mean, the Sacramento Kings case is the same policy issued by Factory Mutual, which raised the exact same arguments and said under California's notice standard, like New York's, that the allegations were sufficient. We allege details not present in Consolidated.
Thank you. You have time for rebuttal.
Good afternoon, Your Honors, and may it please the Court. I'm Harvey Kurzweil. I'm representing all of the respondents. My client is Factory Mutual. There is one preliminary matter. We have 4 respondents. They have deferred to me, but in the event that any questions come up regarding the forms of Allianz or Generali, Allianz or AIG, we have Sandra Hauser representing AIG.
Counsel, can you address your adversary's arguments with respect to Consolidated, his attempt to distinguish the case?
Yes, and of course, Justice Shulman was on the Consolidated panel. The distinctions that are raised are distinctions without a difference or differences without a distinction for the following reason. The contract looks to damage. This isn't a question of science, it's a question of contract law. Physical loss or damage under New York law. What does the contract require? It requires, in the words of this court, some sort of tangible change to the garden. I've watched the Knicks on television many times. Madison Square Garden, I can assure you from what I see, is the same now as it was before COVID.
But the claim is that COVID-19, the virus itself, it attaches itself to the surfaces, it floats in the air for a period of time. Is that a quantifiable change?
No, it's not a quantifiable change. It's a transient event. If the virus is on its own for whether it's a day, a week, or 28 days, it dissipates. It dissipates. The premises, the property remains the same, because even if a molecule lands on the basketball court, that basketball court has not changed. It has not been damaged. There's a period of liability in the contract, which is very important. The period of liability says, with respect to physical loss or damage, the period of liability begins when the damage occurs, and it ends when the damage either could be or has been repaired. There's nothing to repair. The reason why there's nothing to repair, and there are about 40 cases interpreting New York law, they are all consistent. And there are cases, I think the Court of Appeals for the Second Circuit has 9 of them that have been decided. They've all come out the same way. The virus cannot constitute physical loss or damage because that does not fall within the realm of what the contract contemplates.
Sir, based on the contractual language, in consolidated, I think the phrase was direct physical loss or damage, and here that word direct is absent from the policies. Is that material to the analysis?
That's correct. The word direct does not appear in the prefatory language, but in the insuring clauses. Under time element, it's direct physical loss or damage. Under ingress, egress, it's direct physical loss or damage. And under the order precluding entry to the premises, it's direct physical loss or damage. So the word direct is of no significance whatsoever here. And in fact, in the cases in New York, and other cases which we cite in our brief, there have been a few cases which have discussed whether the word direct has any significance. No case that I have found has held that the word direct has any significance whatsoever. One final point before I leave. Consolidated never reached the issue of the contamination exclusion. Here we have a contamination exclusion. The contamination exclusion says specifically that virus is excluded. So to find for plaintiffs, irrespective of their position on physical loss or damage, one would have to literally ignore, disregard the contamination exclusion, which specifically and explicitly says that a virus cannot form the basis for coverage here. Your Honors, this has been extensively briefed. If there are any other questions, I'd be prepared to answer them. Otherwise, I'll rest on our briefs.
Thank you very much.
Thank you.
The Sacramento case addressed the contamination argument as we did in our brief and rejected this argument. The notion that this language unambiguously means what they say it means is an argument that Factory Mutual itself rejected in the case we cited to the motion in limine. They characterized that language as ambiguous and subject to reasonable interpretations. I don't know why that admission doesn't bind them here. But if you look at the physical nature, and with all due respect, direct is missing before physical loss or damage in 2 of the 4 policies. Our civil authority clause is triggered. There has to be a direct result of physical loss or damage, but where you move direct changes the analysis, and we cited the law to that effect. As far as physical alteration, the presence of asbestos in the air and on the ground inside of a space, what's the physical damage from that? You can vacuum it up, you can remove it. Cat urine odor less physical damage, air it out. Mold, dry it out. The fact that it persists for 28 days is material, and it gets re-entrained every time someone comes into the space.
Thank you, Counsel. The last case on the calendar is Concepcion versus Lessel and Midtown.
Good afternoon, Lisa Gokul-Singh for the appellants. The first line in the Court of Appeals decision in Andrea versus Arnone really sort of decides whether or not the lower court should have dismissed the 2022 personal injury action. The court wrote, dismissal of an action for failure to comply with discovery orders is a dismissal.
Can I stop you there?
Sure.
What was the basis to say, in fact, in this case, that there was a neglect to prosecute, that there was a failure to comply with discovery? That's not the basis. The basis here, there were 3 court-issued notices that weren't complied with.
Yes.
So aren't we talking about apples and oranges here?
We're not. You know, Your Honor, this court has now looked at Judge Bluth's notices on several occasions. In Joy versus Navarro, Wilner versus S. Norsel Realties, Malikov, and Avagayan. And in all of those cases, this court has never said that she didn't have the authority to enter these notices. And in fact, the Court of Appeals in Arts for All says that the court can enter into these types of orders.
Well, Arts for All was a CPLR 3126 context, right? So
It was.
Lots of orders are entered in the course of discovery that weren't the product of a motion. That's the only way really we could govern discovery.
Yes.
So this is sort of a different ilk, right? As Justice Singh was discussing, that we're talking about you need to show that there was a neglect to prosecute, so they can't find refuge in CPLR 205A. And so
Yes.
these court notices are obviously, they can serve a useful function and help manage the litigation and try and move it forward. How does their violation transform into a neglect to prosecute within the meaning of CPLR 205?
Because it is still a non-compliance with court orders, and they've been called by this court as discovery
court order, correct?
I'm sorry?
Sui sponte issued court order that wasn't complied with. No complaint from the defendant that the plaintiff wasn't providing discovery, correct?
No, but at this time, again, we were still within the pandemic period of time, and the court was basically trying to streamline how they were handling their court appearances.
Let's look at the exact language of the statute, which says it's the neglect to prosecute, the judge shall set forth on the record the specific conduct constituting the neglect, which conduct shall demonstrate a general pattern of delay in proceeding with the litigation. So it's not enough that it was dismissed. You have to show it was dismissed based on a general pattern of delay. How can these type of dismissals in this case constitute a general pattern of delay where the plaintiff in this case had in fact produced the discovery in the action?
Well, you're making an assumption that the record does not support that the plaintiff had complied with discovery. Don't forget that this action was commenced back in 2017, and the plaintiff was first deposed having violated a number of orders. The PC.
Okay, so let's be more specific then, let's be more granular. It says that they have to put forth in the order dismissing it what the conduct was that demonstrated general pattern of delay. So where in the original order dismissing the case did she show conduct demonstrating a general pattern of delay? And what significance is it that Judge Bluth herself allowed the case to come back alive in the second action? Well, so she didn't find that she had satisfied that standard herself.
That's inaccurate. So first off, it's her order detailing the failure to comply with discovery, and her orders is on page 105 of the record. But her.
You're right, she said neglect to prosecute under the CPL operation.
Well, right, but her denial of our motion to dismiss was not because of want of prosecution. It was actually because she said that she didn't dismiss the prior action on the merits. That's absolutely true. She did not dismiss the prior action on the merits. She overlooked what our argument was, which was that this was for want of prosecution. We also argued alternatively that there was a prior pending action because there were still 2 notices of appeal pending from the prior action. And she said that case is over. And as a result, she said that there wasn't a prior pending action. But this court and the Court of Appeals has said over and over again that when there is a pending notice of appeal, and here the appeal was perfected and is on the calendar today, the prior action was not, had not been terminated.
Okay, let's hear from opposing counsel, and you'll get to respond.
May it please the Court, Ephraim Bortenthal for the appellant and the respondent, Concepcion. There are only 2 bases for a failure to prosecute, either CP Law 3216 or 3126. That's either a failure to comply with a 90-day notice or failure to comply with a series of discovery orders. These don't exist in this case. There was no 90-day notice to serve a note of issue, and there was no failure to comply with discovery orders. There's not one motion in this case for discovery.
Are there any conditional orders?
There aren't any conditional orders. There were several conferences, as in every case, and some outstanding authorizations. They were done. There was no need. There was no acrimony. It proceeded amicably without any motion practice concerning discovery. There was a so-ordered stipulation, discovery order on January 19th, 2021. Plaintiff fully complied with it, and it designated that discovery should be completed by May 4th, be completed by April 28th, a week early. In this case, proceeded quite amicably between counsel. We worked everything out. There is no outstanding series of discovery motions and orders. That doesn't exist over here. And Judge Bluth didn't indicate any, and they never even raised it in their papers. In all their papers in this record, they never raised any issues about discovery issues.
So how about the second issue, counsel? How about the second issue that there was a prior action pending, and therefore it was inappropriate to grant the relief?
Well, that's a misreading of the Court of Appeals cases. Those cases say those cases extend your time past the appellate process. In other words, the plaintiff has the right to extend his 6-month grace period, or under CPLR 205, until the appellate issue resolve itself through an appellate court order. However, that doesn't diminish his rights to recommence the action once the case is dismissed. And I cited the Court of Appeals case of Andrea versus Arnone. That's a case where the plaintiff recommenced the action while the appeal to the Fourth Department was pending. And the Court of Appeals said, plaintiff timely recommences action pursuant to CPLR 205A. Ultimately, the Court of Appeals found it should be dismissed because it was a failure to prosecute. But it said he timely recommenced even though there was an appeal pending. So those cases that the plaintiff cites only have to do with stretching the limit, stretching the time for when you can recommence to when the appellate process is resolved. But certainly once the motion court dismissed the case, plaintiff had every right pursuant to CPLR 205, was a case that was dismissed, to recommence the action. And and it would be sort of kind of a waste of time because the other action actually is before this court. Should the court affirm the dismissal of the original action, then the action is commenced. We would just be back here again. We would recommence the action and be back here again with the same issues. So obviously it would be, in the interest of judicial economy, it would certainly it's something that should be decided right now when both cases are before the court.
Sir, in trying to ascertain whether, ascertaining whether the dismissal was for neglect to prosecute, it was a neglect to prosecute type dismissal and taking it out of the ambit of 205A, are we constrained to look only at the dismissal order, or could we look at some of the ensuing orders that Judge Bluth issued in this case?
Well, I'm not sure. The dismissal order is the order that says the only reason why it was dismissed is because the plaintiff did not comply with those court notices to follow stipulation. And if I may add, the first stipulation was due. By the time the first stipulation was due on May 4th, 2021, discovery had been completed already. So it's not a case where the plaintiff failed to prosecute. It's not that. And that's the order that we should be looking at, that dismissal order, which is based strictly on not following those discovery stipulations. Plaintiff certainly regrets that, yeah, but it wasn't done purposely. And it's proven it wasn't because of any dilatory conduct in prosecuting the case, and that's proven by the fact that Judge Bluth never pointed out even one instance of violating court orders of discovery. That had played no role whatsoever in the dismissal of this case. There's no authority for a dismissal for want of prosecution where you don't have a 3216 violation or a 3126 violation. That does not exist in this case. And I would just add, going to the original order of the dismissal, under our position. It's our position that there was no authority to dismiss, because only authority to dismiss is where there is a violation of discovery orders or 90-day notice or failure to appear at a conference. None of those existed, so there wasn't authority to dismiss. And I would just add one more thing.
You have a minute for rebuttal, thanks.
Okay.
I would just note that the Court of Appeals in Malay versus City of Syracuse addressed this very issue of commencing a new action under 205A while there is a prior pending action, and it discussed sort of the wasteful conduct that would occur. And again, there are two appeals pending in two separate actions here. So I think that this court is bound by the Malay decision, even though it seems to be dicta because the court is just sort of addressing what could have happened if the defendant had raised CPLR 3211A4.
So if we were to agree with your position and say prior action pending, what would stop plaintiff from invoking 205A and bringing a third action?
Okay, so the second part of my argument.
Well, just answer my first question before you get to your argument.
You asked counsel about this. At page 104 in the record is the dismissal, or I'm sorry, is the conditional order of dismissal. And it says that the stipulation or a letter or anything indicating what the status of discovery was due by September 28th. Counsel is representing, which first came in a reply affirmation in the 2022 action, that the discovery had been completed by April 28th. This is news to everyone, including the court, who said on September 28th, 5 months later, just let me know what the status is, or I'm going to dismiss your case. There is a conditional order. And counsel put in all of the orders in this case, and it's very clear that the plaintiff violated every single order in this case.
Thank you, counsel. Thank you.
Thank you.
He has a cross appeal. He has his own appeal.
The basis
You
for
each appeal, so you each get a minute.
Oh, I'm sorry. I thought that was a non-enumerated appeal.
I'm sorry, what?
I thought that appeal was non-enumerated.
You thought what?
Is a non-enumerated appeal. That's what it's listed as.
I gave him the minute, so I'll let him have the minute. You're right, it was non-enumerated, but so technically I was incorrect, but I'll let him have the minute since I
Thank
gave
you.
him, I'll give it. But you're right, I was incorrect to give him the minute.
Thank you.
Maybe only 30 seconds.
Okay,
You
all
really
right.
have a right.
Okay, as I said, Judge Bluth's order had absolutely nothing to do with any outstanding discovery whatsoever. It had nothing to do with that. I would just like to point out one thing, that the defendants were equally remiss because the burden was on both parties to follow stipulation. They did nothing. I would just like to read one sentence from the court's decision, Melikov, from December 15th. It says, under these circumstances, which is also Judge Bluth's order, where the plaintiff didn't comply, it says, under these circumstances, dismissal of the action after all parties had failed to comply with the court's notice unfairly penalized only the plaintiffs. That's what's happening over here. They were equally remiss. We're being penalized for no reason that they should be equally penalized.
Thank you.
Thank you. Thank you. Okay, Ms. McGee.